members of the City Council. I'm Javier Chacon. I'm an EEO consultant and retired Deputy Director of the Equal Employment Opportunity Commission with EEOC Houston. I have over 35 years of EEOC experience. I'm here as a friend of Ms. Swilling and also her consultant, asking you to meet with Ms. Swilling and her team, and hopefully I'll be invited, in pursuit of addressing available evidence which was apparently overlooked or possibly ignored, I repeat, ignored, regarding her termination in 2008. As indicated by Ms. Swilling, she did not have the full IAD report, so she was limited as to what she had even when she went before the court. So it's obvious that she was not dealing with a full deck of everything that was identified in that report. It's also obvious that the police department did have, whoever made those decisions did have all the evidence that they wanted to see and use regarding their charges that were used against her, leading to her termination. Mayor Parker, I know you're fully committed to equal employment opportunity for all. And in this matter, it requires your immediate personal attention in doing this, the right thing, in providing this lady a rightful opportunity to present everything that was apparently ignored or overlooked. And that's what I'm asking you and your counsel. Thank you very much.
Sir, you indicated you were a consultant. Are you, in fact, representing her as an attorney?
No, I'm not an attorney. I retired as a deputy director of EEOC. I've been with the EEOC for over 35 years, but I'm not an attorney. I'm just an EEO consultant.
Councilor Green.
Thank you, ma'am. Mr. Chacon, good to see you. Again, with regard to this particular case, was she represented by counsel at did she have a union lawyer?
I cannot answer that because I'm new to this matter. I'm working with her through the Greater Houston Coalition for Justice, and because I'm also one of their EEO consultants.
Okay, and so what specific policy are you asking? Are you asking us to revisit? Are you asking the city to revisit a certain hearing policy? What is it specifically that you're requesting?
Whatever's in the power of the mayor and possibly this council to provide Ms. Swilling the opportunity to present the evidence that was overlooked or ignored by the terminating officials from the police department, leading to her termination in 2008. And now, whether that's through a meeting to determine if it can be sent to some sort of a hearing or whatever your processes are, I'm not familiar with your processes.
Okay, and so let me ask legal then, is there an opportunity for an evaluation of what he's asking for? Do we provide for that or no?
Mayor, council members, let's clear up the record. Ms. Swilling filed a federal lawsuit. Judge Hittner granted summary judgment in favor of the city of Houston. She took the case up to the Fifth Circuit Court of Appeals. Fifth Circuit upheld that decision. She did not appeal to the U.S. Supreme Court. The case is dead.
She doesn't have any money, and the evidence, and she didn't have the full evidence that was provided to her as she made a request.
But she went through arbitration prior to the federal appellate process.
Yes, ma'am.
Councilmember, do you have further questions?
No.
Councilmember Adams. I'm sorry. Councilmember Craig.
Thank you, Mayor. Mr. Chacon, how long have you been Mrs. Swilling's EEOC consultant? How long have you been?
just recently, about maybe 2 or 3 weeks, reviewing whatever information she has made available to me.
You indicated that when Ms. Swilly represented us here, pro se before the court, that she didn't have the full IED report. Are you saying today that she has it, and if so, how long has she had what you call the full IED report?
It is my understanding, and Ms. Swilly is in a better position to answer this than me, that when she went to court, she did not have the full IAD report, even though she had requested it through the appropriate channels to get it.
Is it your understanding that she has it today?
It is my understanding that she has it today, yes.
And I'm not clear what you requested, because there's a pretty definite review process in place to handle personnel issues, and when those processes don't work in favor of the employee, or as the employee thinks they should work, then there's the civil court process. That's what that process is there for. So once an employee has exhausted the administrative remedies, whether it is a hearing examiner, arbitration, etc., and they go to the civil court process, what else is it that you want the city to do?
Well, again, I'm not familiar with your processes that are available through your city council, but apparently there is a suspect practice dealing with the police department where when people file EEOC charges, there's an issue that they trump up charges that are not justifiable.
Well, Mr. Chapman, I hate to cut you off, but as a seasoned administrator, motion to extend, please.
Second discussion, failure to oppose, motion carries.
Thank you kindly. You represented to be a deputy administrator that's helping EEOC. You must have looked at hundreds of cases. And you know, at some point it has to be, the decision has to be made based on the evidence that's in the file that can prove either more so happened or didn't happen. So what is it you expect this body to do, or the city to do, that is within the generally acceptable principles of an administrative process? Being a deputy director of the EEOC, surely you understand that there's a process that must be adhered to.
Right. Since apparently the existing processes that were made available to Ms. Swilly did not allow her to present all of the evidence that was in her, all of the investigation that had been done by the IAD, it is her position that whatever she went through in terms of making her representations through the different avenues, administratively and judicially, were not with all of the possible available evidence. So we're coming to you and asking you to allow her to present this evidence to whatever vehicle you dictate to her, because I wouldn't know. I don't know your processes.
Okay, one last question, please. One last question. So even when she went to court, she didn't have this full set of evidence, and if she didn't have it, how did she get it?
She eventually got it through a request for information through the Open Records Act.
Okay, so it means it was there and available throughout the entire process.
And they did not make it available.
Thank you for your testimony. Thank you, Mayor.
Councilman Brown.
Thank you, Mayor. I guess this question is more directed to the administration or legal, just a clarification for me. If you have a former City of Houston employee and they went through all the processes, federal, local, and the City of Houston upheld it, and then it's a couple of years later, what's our process from this time moving forward? Is there anything that can we do? Do we reopen it? Do we send it back to who's in charge now, the current, police chief, what's the processes of move forward, so there's no false hope given on her side, and so we'll know the knowledge that we have as council members, so I don't know what those processes are.
It's the city's position that she has exhausted all of her avenues of appeal and has been through the formal process up to and including, appearance for a federal judge and appeal of that, so.
And Mayor, just as an FYI for the council, during the course of the administrative and civil process, she had 10 lawyers throughout the process that were involved. Not all at the same time, but she fired one, hired a different one. And she did receive the internal affair investigations in full during the litigation.
Okay, so at this time, what you're saying that there's nothing else that can be done, I'm just saying, just from a general, perspective from anyone, it just so happens she's the person we're talking about today. So legally, because she's approaching council and asking us to do something, so legally, what can we do, the mayor do, is there anything that we can do since they're asking? I just want to be able to provide them with an answer.
That's the point of the appeal process. You need to know. The Court of Appeals affirmed the summary judgment. She did not appeal. It's final.
So it's done.
It's done.
Okay, that's all I just wanted to clear up. Thank you, Mayor.
Vice Mayor Pro Tem Brown.
Thank you, Mayor. I want to just respond for Mr. Sarkon purposes and in response to what Councilmember Adams inquired about. I have a practice as police chief because when you step into the chair, many people are going to come forward asking you to open up files for decisions that have already been made. My standing practice was, if that person could not show objectively that there's new data that was not considered during the previous investigation, I would not reopen any file. If they were able to show objectively that there's new probative data that was not considered during the previous investigation, then I would look into it. And I don't know if that's the case here or not. That's the rule I use as a guide on there. Thank you, Mayor.
Thank you.
Thank you.